Good evening, Mayor Holman and council members. We met in early January, or excuse me, it was late January. I'm Margaret Nanda. I'm the attorney for the park owner, Buena Vista mobile home park owner, the Jisser family. I want to start by turning around and doing the same thing which I did at the 3 public hearings that occurred in May of 2014, which is to acknowledge the residents of Buena Vista who are here tonight and their supporters, but in particular the residents, and acknowledge the very difficult situation that they find themselves in. My client and I are not unmindful of that fact at all. What is before the council tonight is in fact a legal question. And I would submit that there are 3 things which form the legal basis for a park closure. In this case, most importantly, and we begin with the Palo Alto, your own ordinance, which this council, I realize not the people sitting in these seats, but the Palo Alto City Council created with one park in mind, Buena Vista. In 2000, there was only one park in Palo Alto. There is still only one park. It was Buena Vista. The ordinance was created with the input of the residents, as we even heard testimony about tonight, and with the advice of the residents' attorney. In addition to the conversion ordinance, and as the ordinance itself acknowledges, state law, in particular the government code and the mobile home residency law, a portion of the civil code which governs the relationship between park owners and tenants, governs this process. And finally, of course, there is the United States Constitution, which of course contains the 5th Amendment, which prohibits the taking of private property by the government without just compensation. I start with this because in the discussion of mitigation assistance that we have heard tonight, the mitigation assistance in a mobile home park closure is not unlimited. But let me begin even before that and articulate for the council, as was articulated by Craig Labadie, the hearing officer, and as has been articulated by our local 6th District Court of Appeal, Justice Patricia Manukian, and is indeed contained in state law, the government code. A mobile home park owner in the state of California can exit the rental business. That is the law. This family can close the park. They can close it, and they do not even have to convert it to another use. But they can close it, provided that they follow the law. And in our case, we have to follow the ordinance as well as state law. And I would submit that we have. We have heard a lot about the inadequacy of the mitigation assistance that has been offered. So let me start by saying that there is no confusion on this point. The mitigation assistance, which is being offered by the Jisser family regarding the closure of Buena Vista, is that which is contained in Exhibit A to the Craig Labadie decision. Mr. Labadie, a hearing officer who was chosen by the city attorney's office without input or consultation with, I believe, either side, but certainly not the park owner, who I was told in my one telephone conversation with Molly Stump before the hearing in January, and Grant Collin repeated the same thing. They had tremendous respect for him. He was a highly regarded member of the California League of City Attorneys, and he was a former city attorney for the city of Walnut Creek, where there are a number of mobile home parks, and in fact, very intense mobile home rent control battles. So Mr. Labadie's decision, Exhibit A, is what we are proposing. So we are not arguing or proposing anything other than what he found to be reasonable mitigation assistance. What Mr. Labadie acknowledged, and which the Residents Association does not acknowledge, is that there are in fact limits on mitigation assistance under the government code. And again, your own ordinance sets forth that it is subject to this government code section. which provides that the steps required to mitigate shall not exceed the reasonable cost of relocation. And indeed, Mr. Labadie discusses that at length. And again, I'm citing their Palo Alto, your section 9.76040, subsection G of the ordinance. You have that exact same language in the ordinance. So there are limits on the mitigation assistance. Then Mr. Labadie, in his decision, in his final decision of September 30th, and you have before you, I see many piles of paper, even the record that is before you does not constitute the entire record of the case or that which Mr. Labadie examined in his decision. And he says, after careful consideration, his ultimate conclusion was that the park owner had met its burden of proof and that the package of mitigation assistance, which taken as a whole and with certain supplemental conditions, which are in Exhibit A, do meet the criteria set forth in the city's ordinance and requires a mandatory approval of the application to close the park. So, Council for the Residents Association has already gone through elements of the mitigation assistance. Now, the first item is the appraised on-site fair market value of the home. We did not pick Mr. Beccaria, who will testify tomorrow night as our expert, out of a vacuum. I have been, as I explained to the council in January, practicing in the area of mobile home law for 35 years, and I believe I am the only person in this council chamber who has actually participated in and indeed led 6 other closures, and I'm currently at work on 4 other closures. I have closed 2 parks already in Sunnyvale, and the 3rd is under closure. And that 3rd park is literally a 1.5 miles down the street from Buena Vista. Mr. Beccaria is the most highly regarded mobile home appraiser in at least Northern California, if not the state of California. But you will see his own rebuttal tomorrow. But we picked him with the approval of the city. The city has a list of appraisers, and we said who we wanted to use, and the city approved our choice of him. And I might add, your own ordinance, again, we did not design the ordinance, we are subject to it. Many other cities, San Jose, Sunnyvale, Fremont, they provide for an appraisal within 6 months of the date that the park owner is going to purchase the home, which is what we ultimately proposed. Your ordinance requires an appraisal to be done at the outset of the process before the first resident impact report is submitted. The first resident impact report was submitted in May of 2013. The appraisals were completed in April of 2013. So the fact that they were old, or that they are now considered old 2 years later, or they used data that was available to him then, is because of the terms of the ordinance. The ordinance requires us to pay 100% of on-site fair market value, and we are offering that. Now, next, the hearing officer has approved or stated, as per the terms of the ordinance sets forth what are things which should be offered as mitigation assistance. It's a rent subsidy and startup costs. We amended the RIR on the last night of the public hearings for one reason and one reason only. Because for the previous 2 nights, the residents had been testifying about 2 issues. The appraisals were too low, and the proposed rent subsidy of 40% was way too low. So we amended it to provide, as many other ordinances conversion ordinances throughout the state of California do, for an appraisal within 6 months of the purchase to give them the latest and best value of the home, and furthermore, to increase the rent subsidy to 100%. You can't increase the rent subsidy to more than 100%. Then they are entitled to startup costs for the first and last month's rent and security deposit. What does that equal altogether? It equals that for 15 months, they pay the same rent wherever they choose to go as they are currently paying at Buena Vista. The fact that the ordinance says that the rent subsidy is for a period of 12 months is not of our doing. It is your ordinance. We are complying with the ordinance. The Residents Association is suggesting a longer subsidy would be appropriate. Your ordinance does not require that. And Mr. Labadie did not order that. His decision did not find that. They argued at the time that what we were suggesting as a reasonable amount for relocation of personal property was not adequate. He accepted their argument. He said it should be actual reasonable moving costs. We are not opposing that. We have accepted that. Actual reasonable expenses for 2 nights in a hotel motel during the moving process. Again, we have accepted that. In addition, he said there should be additional assistance for handicapped residents for packing or other physical tasks and the cost of replacing special equipment. And I might add that, again, the Residents Association has throughout this process made many disparaging comments about the housing relocation specialist. Again, the housing relocation specialist here was chosen with the approval of the city and is an experienced housing relocation specialist and is not our agent, as they have often stated. That he is paid by the park owner because your ordinance requires it, but he does not work for us, okay? And if you think that he is our agent, the testimony that he gave at the first hearing, which by the way was before we introduced the amendment on the 3rd night, that testimony is before that time, but if you think he was testifying necessarily in our favor, they're arguing he was not. So he's not our agent. I point this out because Craig Labadie, in his decision, gives a number. They're saying there's nowhere for these people to go under this relocation plan if they disagree with something. Read Exhibit A. He says, Craig Labadie says at the end of the opinion, I'm not going to retain jurisdiction here, but the housing relocation specialist is capable of making decisions and binding those upon the park owner. So for example, if the housing relocation specialist said that a certain amount is due for additional assistance, it is up to the park owner to pay that, because that is Craig Labadie's decision, and we have accepted that decision. So I think it's very important also that the council recognize that the payment here is a lump sum payment. The Residents Association made light of that fact, but it is not. It is a very important fact, because what it in fact means is that the amount of money that the residents will receive will be paid in a single check without regard to where they decide to go. So it's based on average rents in Palo Alto and surrounding cities, not cities within 35 miles, Palo Alto and surrounding cities. And that is what he has ordered. So if they choose, which I'm not suggesting they should, but let's say they choose to go to the East Bay, which is still within the 35-mile zone they've just chosen, they may get rent which is lower than that which is going to be paid by the park owner. And again, the ordinance says it's only for 1 year, with plus the startup cost, which is the first and last month's rent and the security deposit, in fact represents 15 months of rent. So now what we have done, and which we have done, is we have prepared a sample of the actual mitigation assistance that a tenant would receive if they were moving to a 1-bedroom apartment. And I will address the 1-bedroom versus 2-bedroom issue in just a moment. Now, at the time that we first prepared the statement for this council, we did not have the opposing counsel's rebuttal and their position that David Beccaria's appraisals are faulty as prepared by this expert in Escondido. If you look at what Mr. Beccaria submitted in writing already to the council, he is estimating at present a 31% increase in the median mobile home price between 2013 and 2014. So if you take the average value of the home, the average value, original appraised value of a home at Buena Vista was $18,816. Today, that if the park were closing today, which it is not, it would be $24,000. I'm reading this right. $24,649. The 12-month rent subsidy, that in and of itself would be $22,441. The startup cost, the first and last month's rent and security deposit, would be $7,860. The moving cost, we have estimated here at $1,100 because that is the figure the Law Foundation used in their briefing, original briefing. The disabled assistance is to be determined. That amounts to a package of $56,050. If the homeowner had a 2-bedroom home, again, and it was originally appraised at the median value there, originally of $18,816, a 2-bedroom home with a 31% increase would be $24,649. The 12-month subsidy would be over $27,000. The startup cost would be over $9,000. The moving cost at $1,100, it amounts to $62,103. So now I want to show you an example of an actual appraisal. And again, these were provided to the city and to the planning department in soft copy. So these are part of the record that the city had and which Mr. Labney had before him. On page 3 of every David Beccaria report, there is something called a summary of the salient features. I have redacted for purposes of this PowerPoint the space number and the name of the tenant. In this case, what is being appraised is a 1955 travel trailer with addition, note the addition. Now, he has found a value here of $17,000. I would like the council to note that under the $17,000, he says, there is no off-site value noted for this unit. Now, the reason I bring this to the council's attention, what that means is that if that mobile home were not located at Buena Vista, it would have zero intrinsic value. It has no value. And I remind the council to return to what is in fact reality. Of course these are these people's homes. Of course they are their homes. But they are items of personal property. They are not real estate. They are not stick-built housing. And what this park owner is going to do, in fact, if he buys these at their appraised value within 6 months of Mr. Beccaria's reappraisal, what is he buying? He is buying an item of personal property, and he is buying that for a value which reflects its value on his own land, which he already owns. And I submit to you there are serious constitutional questions with that issue. Because the only reason this home is valued at $17,000 is because it is sitting in Palo Alto on property he already owns and which he is renting. So I submit and I preserve our objection for the record because, again, I think there are serious problems when the value is only because it is sitting on land he already owns. Further, the Residents Association continues to ignore, and I take nothing away from any speaker tonight about their love of their home, their love of their schools, the close community they feel they have. But Buena Vista is not a traditional mobile home park. I assume that every council member here has walked the park and seen the homes. Only 30 of the 108, only 30 homes there are in fact mobile homes within the definition of either the Health and Safety Code or the California Administrative Code. The rest are RVs, travel trailers, or trailers, some as old as the early 1950s. They were built for temporary recreational use. The park does not have proper infrastructure to even support a modern mobile home. The average square footage of the homes does not compare to modern mobile homes. For example, in the Trulia data, which they have submitted to you, the average of those homes are 1,120 square feet. The average home at Buena Vista is 458 square feet. That is a big difference. The average age does not compare. The Trulia listings, which they submitted to you, the homes are 17 years old. The Buena Vista homes average 39 years old. That is the average. So let's take a look at a couple of units at Buena Vista. So number 29, okay, that is a recreational vehicle. It is not a mobile home. It is a mobile home because it has been located in a mobile home park for longer than 9 months. That's a part of the statutory definition of a mobile home under the mobile home residency law. Then, if you look at the picture on the right, number 59, you see what has been discussed by Mr. Labadie and which was discussed at length in the RIR. So what has happened here is that is a mobile, that is in fact also a type of RV to which a structure and addition has been added, okay? And Mr. Beccaria's reports, and he will say tomorrow night that with the exception of, I believe, one person at the park, none of the additions were done with permits from HCD or anyone else. So now, then we have, then if you look at, for example, the unit at number 47 that we have in this picture, from the front, it indeed appears to be a mobile home. But when you go to the rear, you see that this person has merely erected walls around the home. And in fact, that again is a type of recreational vehicle and not a mobile home as you may be used to thinking or they are suggesting are comparable mobile homes by way of the listings in the Trulia data. Then finally, if you walk to the park, no doubt you notice, and this is again, this home is a mobile home. It's a single wide mobile home. I'm talking about the silver portion of the home that's on the right, in the right picture. What this homeowner did was literally enclose the asphalt around his space. And if you will notice the picture in the tree grows out of the center of the roof. He enclosed the space. So what you are seeing there is this additional modification which added bedrooms to the home. So when we are discussing comparable homes, this is what the Residents Association gave you as listings of comparable housing, okay? And these are located at a park in Mountain View, and it is a senior community. And when we, in the Resident Impact Relocation Report, when we gave as examples senior parks, the Residents Association criticized us because Buena Vista is a family park, but these are the listings which they are submitting are in fact comparable housing. I would submit they do not look like the units at Buena Vista. So if you look at the Trulia homes, and there are some pictures of what the interior looks based on the listings, and then you see the units at Buena Vista, they are not comparable. And I think that Craig Labadie recognized that fact. And you cannot, and the fact that they are located in Palo Alto does not transform the physical characteristics of the home. They are not, in fact, comparable. The vast majority of Buena Vista homes are modified trailers, not traditional mobile homes. Even some of the mobile homes have been modified, and they are not, in fact, comparable mobile homes to what they are suggesting. The other thing I would like to suggest to you is that listing, we all know, or I would believe that we might share a common belief, that we can all list our home for any amount of money. The question is, what is someone going to pay for your home? A far more reliable source of data for what mobile homes are in fact selling for, not being listed for in the communities surrounding Palo Alto, is data which is available from a service which picks up the actual sales data through the Department of Housing and Community Development, which is the only agency in California which titles mobile homes. And we submitted some of that data during the hearing to Mr. Labadie. I did not bring that data with me tonight. We could track and we could provide you with what every single mobile home park in Sunnyvale, Mountain View, Santa Clara, San Jose, every mobile home within that park sold for within any amount of time. 1 year, 6 months, 4 months, the data is there. We're not to introduce new evidence tonight, so I did not bring that data. I will represent to you that there are homes in all of those communities that do sell for $50,000 and under. Now, the problem with the Residents Association argument tonight about the uniqueness of Palo Alto, and I do not live in Palo Alto, and I am not debating the wonderfulness of Palo Alto. However, the only way these residents remain in Palo Alto is, and are homeowners, as they suggest they should be, this is in their brief. Payments to mobile homeowners should allow them to move to and purchase comparable ownership housing, mobile home or condominium. So to remain in the Palo Alto schools and the city of Palo Alto, it would require the park owner to purchase condominiums in Palo Alto for these residents. The average price of a condominium for sale in Palo Alto today is $1,247,500. Does that exceed the reasonable cost of relocation? Yes, it does. And I don't believe that anyone can disagree with that. The fact that there are not affordable housing options for these residents to go to within Palo Alto and remain in the schools and within this community that is so dear to them is neither the fault of the park owner nor the park owner's responsibility. It is not the park owner's responsibility to build affordable housing in Palo Alto. I submit it is the city, it's the state, it may be the federal government, as their expert has suggested, but it is not the park owner. Now, then, of course, there is the argument, which Mr. Labadie accepted our argument about the schools. In fact, if you looked at the record in this case, and we did include that in the record, there is a record of the council meetings that occurred when the ordinance was enacted. And there is more than adequate language about how the assistant city attorney at the time, Ariel Colon, looked at a number of ordinances, and the residents were represented by an attorney. And I believe that you probably would agree that the Palo Alto schools were excellent in the year 2001, also when the ordinance was passed. And the ordinance does not name schools. And Mr. Colon practically copied verbatim the city of Monrovia mobile home conversion ordinance, and that specifically references schools. And moreover, in those days, the city of Sunnyvale, the city of San Jose, they all had conversion ordinances. They had had them since the 80s. Those local ordinances also mention schools. Yours does not mention schools. What does Mr. Labadie find on this issue? He acknowledges what you all heard tonight, undisputed, that Palo Alto schools are among the best in California and are highly valued. But he says, without in any way minimizing the importance of this information, it does not directly factor into the criteria listed in the conversion ordinance. And why is that? Because there simply is. He found that on this record, and considering the plain language of the conversion ordinance, there is no basis for implying a legislative intent, meaning an intent by the council, to require analysis of available schools when determining what constitutes comparable replacement housing. The ordinance is what the ordinance is. It is not what the resident association wants it to be or wishes it to be. This is what the hearing officer chosen by the city attorney's office found in relation to that issue. So what is the task of the city council? The task of the city council is to act as a judge. It is to act as a judge in this matter, but it must follow, I submit first, your own ordinance as well as state law and constitutional principles such as the Fifth Amendment. And I think most importantly, and if you have read Mr. Labadie's decision, which I'm sure all of you have, on the very first page, and I think either the first or second paragraph, he says, and he acknowledges, that he was very moved by the resident testimony, and he is mindful of the decision, the impact of the decision
But my factual and legal conclusions must be based on evidence and reasoned analysis, not emotion or sympathy. Okay, I will, that's it.